Hello everyone, and welcome to today's training session on how to make best use of the Unitary Patent, with this particular focus on questions, issues that startups and small and medium-sized enterprises face in that regard. This afternoon, we'll dive into how patents, and the Unitary Patent in particular, can support high-growth technology businesses, strengthen business development, and facilitate IP transactions and valorization. We're delighted to see such a strong turnout today, and we hope this will be both insightful and inspiring for you. This training is brought to you by the European Patent Academy of the European Patent Office, together with the European Innovation Council. And we're especially pleased to welcome so many EIC beneficiaries among our audience today. My name is Stephanie Weber. I'm a member of the team behind the European Intellectual Property Help Desk, an IP service initiative of the European Commission. We've been collaborating with the EPO and the EIC for a very long time, and it's a pleasure for us to support this training and for me personally to guide us through this program today. We have a great lineup of speakers who are excited to share their experience and insights with you. So with that, let's get started. And I'm very pleased to now introduce you to Raquel Csalabarder. She's the director of the European Patent Academy. She's taught and written in the field of intellectual property, copyright, private international law. And we're very happy to have her here today. And she'll be joined by Viorel Peca. Viorel Peca is the head of unit at EIC Transition. He joined the European Commission a while back in 2008, and since then has held several leadership positions at the intersection of deep tech innovation, digital transformation, and strategic R&D policy. Welcome to you both, and the floor is yours.
Welcoming you once again to the joint efforts of the EPO and the European Patent Academy and the European Innovation Council, co-organizing another training activity, as Stephanie was saying, on how to make the best use of the Unitary Patent system. We all know the Unitary Patent is here to stay. We've had over a couple of years of it. And we at the EPO, as patent granting authority, we are delighted to contribute to a better understanding of this new, not so new anymore, Unitary Patent. Both the EPO and the European Innovation Council share a strong commitment to empower innovators and entrepreneurs across Europe. And in 2023, we made a further step in this commitment by signing a letter of intent with EISMEA, which is the agency implementing the EIC programs. Based on that, for these past couple of years, EPO examiners have been contributing to the evaluation of EIC proposals, and we have been developing together specific training activities for EIC beneficiaries, which we are delighted to see that they continue to raise a lot of interest in terms of accessing the recordings and the publications that follow these trainings that we jointly develop. It is a win-win for all of us and hopefully for all of you. And we are very satisfied with this institutional cooperation, which is very much aligned with the EPO's strategic plan for 2028. At the EPO and at the Academy, we believe in the transforming power of continuous learning and sharing knowledge. And we are delighted to support business and entrepreneurs on how to make the best use of the patent system for their own advantage and for the advancement of innovation and economic growth across Europe. Today, as Stephanie was saying, we're focusing on the Unitary Patent and see how business and entrepreneurs can benefit from it. And I hope you enjoy the training. I also hope to see you at other Academy trainings. Visit our e-learning center. You had the URL here, because I'm sure you may find other activities that you may also like. So now I think I'm gonna give the floor to you, Viorel, because I believe Steph may be still in a bit of...
Yes.
So thank you so much.
Thank you, Raquel. I hope you can hear me well.
Yes.
Indeed, EIC and EPO have a strong collaboration already for some years now, and this is due to our common passion for support European innovators, but also the good work of our colleagues who are putting this passion in concrete actions for the benefit of European innovators and EIC beneficiary, like today training. From the EIC side, this is my colleague Adéla Dvořáková, and from the EPO is Thomas Bereuter and Bente Fjellberg. And of course, from IPR help desk, we have Stephanie Weber. Thank you very much, colleagues. This training on unitary patent cannot be more timely. Today, we are living, as we see every day almost, in a complicated geopolitical situation, and the technology has never been so important. We are talking about geopolitics of technology and not since yesterday. And if technology has never been so important, then patents have never been so important. Just to demonstrate this, patents are not anymore the talk of specialized publications, reading by very specialized people, but are featuring on prominent news and media around the world. As just to give one example, as recently as last month, New York Times ran a very long article called "How China Went from Clean Energy Copycat to Global Innovator." And to demonstrate this, they use patent figures provided by EPO. So title was all about geopolitics, while content was all about patents. More exactly, patents in clean energy, that is battery, solar, wind, and smart grids. And these figures that you see also on the screen caught my attention, as they are really, really impressive. If in 2000 Chinese applicants filed 18 clean energy patents that analysts say they were international competitive, in 2022, Chinese applicants filed 5,206 patents, well ahead of European Union, 3,181, Japan, 3,906, and even all the 39 EPO countries combined, 3,722. And this in a domain in which the European Union and Europe more broadly give a lot of attention at political and policy and even economical level. So as you have heard the figures, Europe more broadly was only on the third place after Japan, and the EU even on the fourth place. And by the way, these figures are also confirmed by a more detailed EPO report, EPO and EIB publication in 24, Financing and Commercialization of Clean Tech Innovation. If you look more carefully at the chart, it is really astonishing to see the number of how the number of Chinese patents skyrocketed in 21 and 22 to overtake everything, EU, Japan, and again, starting from a very low base in 2000. And it's not only New York Times, also BBC in a recent article titled "UK will not be able to resist China's tech dominance," find the same huge progress in terms of patents. China now files 3/4 of all clean tech patents versus 20th at the start of the century. And in terms of patent, more generally, more patents are filed in China than in the rest of the world put together. And BBC gives the figures. In 23, China filed 1.7 million patents against 600,000 in the US. 2 decades earlier, China had a third of the patents filed by the US and a quarter of Japan, and was well behind South Korea and Europe. And talking about South Korea, they announced recently that they will transform their intellectual property office into a ministry of intellectual property, with authority like any ministry to propose legislation, participate in cabinet meetings. And of course, this is they done this with the hope to secure their or increase their leadership in critical technology. But on our hand, perhaps this will be an example for other countries. Who knows? All these figures and news and information to say as an intro to our training today to say that patenting has never been more important in today's competitive geopolitical situation, and Europe can do better. In this context, I really believe that the unitary patent can be an important tool for European researchers, spin-offs, and deep tech startups to protect your breakthrough research result in your journey towards innovation and market, and to attract much needed finance, and then for Europe to improve our competitiveness position. But why is this the case, and how you may ask exactly? Well, this is why we put this training for you. So I'm sure you are looking forward to discover exactly how in the next hour. So thank you very much, and looking forward to your feedback. Colleagues, over to you.
Thank you very much for your encouraging words, Viorel. That is absolutely relevant. We really have to move forward in respect to making proper use of intellectual property rights. Viorel, ESC is a very important partner for the EPO. And as we now move forward to the next presentation that is coming from Eskil, I'm happy to introduce our colleague Eskil Waage. He's from the Patent Development and IP Lab team at the EPO, and he heavily contributed in making the unitary patent system possible. So for many years, he was involved before it got established. Eskil studied law in Copenhagen and Strasbourg. He joined the EPO in 1998, contributing to the revision of the EPC, the EPLA, and the London Agreement, as well as the Unitary Patent and the Unified Patent Court projects. He currently heads the EPO's framework for user consultations, that's the SACIPO Secretariat, and is a member of the EPO's disciplinary board for professional representatives. So Eskil will give us introduction to the unified patent system and the court system and enforcement strategies that are possible. So Eskil, up to you. Please take over. Thank you.
Thank you very much, Thomas. Good afternoon to all of you, also from my side. I was asked to give an overview of the patent protection system in Europe in 30 minutes. So we're going to start with some fairly basic aspects and then focusing on the unitary patent and the unified patent court, explaining in a nutshell what could be in it for you, the pros, the cons, the risks perhaps, and certainly the advantages. So we start with the basics. What is a patent? It is a contract between two parties. On the one side, the inventor, who with his or her skills, knowledge, creativity has made an invention. On the other side, the public at large, society, to which the invention is revealed in exchange for a period of exclusivity for the inventor. That system has worked fairly well for at least 150 years in our Western world, to a large extent because it achieves a win-win situation for both parties to the contract. There are benefits for the public insofar as a detailed description of the invention is made available to everyone. That happens 18 months after filing of the patent application. Also, the owner, the inventor, is benefiting from the system insofar as he can prevent third parties from exploiting the invention for a period of maximum 20 years. Sounds good, you could say. except that it's not always so easy to obtain a patent. There are conditions, what we call the patentability requirements. First of all, at a general level, patents are only granted for inventions in a technical field. Secondly, there are three main substantive patentability requirements. To obtain a patent, inventions must be new, must involve an inventive step, and must be industrially applicable. Note finally that a patent can relate not only to the product, so all the things we have around us, but also to a process, to an apparatus, or to a use. There are several exclusions from patentability. Here is the list. Might seem rather long, but most of these exclusions actually make perfectly sense, even at first glance. A discovery, scientific theory, mathematics, computer programs, aesthetic creations, all this, if claimed as such, is not patentable at the European Patent Office. This brings us to briefly compare patents with other intellectual property rights, IP rights. On the left side of the screen, you have the list of these IP rights, so patents, our topic today, but also copyright, trademarks, registered designs, and trade secret. In the middle, what these IP rights cover: inventions, creative artistic forms, literary text, music, paintings, as far as copyright is concerned. Trademarks are necessary for distinctively identified products and services. Designs to protect external appearance of products. And trade secrets, finally, in case valuable information can be kept secret from the public. On the right side, how to obtain protection by means of these IP rights. Patents are granted by patent offices after an application, search, examination stage. Copyright exists automatically when the artistic work is created. Trademarks are frequently registered at a trademark office, but can also be acquired by use. Registered designs are equally registered by a public authority. Only trade secrets can be kept secret and can be protected if they are kept secret or if reasonable efforts are done to do so. I must also here compare with a last IP right, namely utility models. And you see here a table with the characteristics of utility models and patents. To make it short, sometimes we call utility model a fast IP right or small patents, because indeed the requirements for obtaining utility models are less strict than for patents. The fee, it's less costly, the fees are lower, but also the protection period is shorter, and there is no substantive examination of the patentability requirements as we have them for patents. Coming back to patents, how to obtain one. Here an overview of the three routes, the three paths to patent protection. You can go national, filing a national patent application, usually at the patent office of your home country. And you will then get a patent covering, protecting your invention only in that country. In the middle of this slide, the European route to patent protection is where you file a European patent application, which, if granted eventually, may cover 39 states. I have the map here on this side to illustrate that Europe is almost entirely covered by the European patent route. So all the EU countries, but also Iceland, Norway, the UK, Turkey are participating in the European patent system. There's an extension state, and also validation is possible. So that we are up over 40 countries participating in the European patent system. Coming back here to the route, stressing that the European patent application is one single application dealt with by the EPO in one of its 3 official languages, German, English, or French, which may result in the grant of a European patent having the same legal effects as national patents in the 39 member states of the organization and the 5 extension or validation states. I also have at the right a mention of the PCT route, the international, the procedural way to obtain patent protection worldwide. This is not a patent granting system, it's only a way to secure the first stages of the patent process. Finally, to conclude this first part, a brief word about the legal aspects of the European patent system. All this is based on the convention, the European Patent Convention, which is the legal basis for the existence of the EPO and all what we do. It's a convention dating back to 1973, that's 52 years ago. And it has been a very successful system with today more than 80,000 European patents granted every year on average. It provides a clear, legal, consistent framework for patentability and ensures legal certainty, predictability, high quality of the European patents granted by the EPO. All this being of critical importance for businesses, for their planning, their investments, the licensing, exploiting new technology. Let me turn now to the unitary patent, the newcomer in Europe. It's really rapidly changing the patent landscape. What do we have here? We have on the one side the new unitary patent based on 2 EU regulations. And on the other side, we have a new unified patent court. Now that's the true revolution of the new system. It's really a new treaty. It's a new court created by a new treaty, so that 18 member states of the European Union give competence to a new court to deal with patent litigation. All this is still fairly new. The unitary patent system with its 2 components, entered into force on 1st of June 23, a little more than 2 years ago. It's a new option. The unitary patent is a new option. It's a new offer to all those who obtain a European patent. So you need to first apply for a European patent, go through the search examination procedures at the EPO. And once the European patent is granted, you have a choice. You have a new choice. In the past, you could only validate the European patent in one, more, or all of these 39 member states. Today, now with the new unitary patent, you have the possibility to request unitary patent protection in up to 18 EU member states by asking the EPO to registering a unitary patent. That gives the owner of unitary patents a broader protection. It's a cost-effective new option. And last advantage, we'll come to that, there is one common enforcement system. All litigation relating to unitary patents take place before the Unified Patent Court. Here another map with the 18 EU member states participating in the unitary patent system. So again, I stress this is an EU project. The goal is that all EU member states eventually will participate in the EU patent system, in the unitary patent system and the Unified Patent Court. So far today, we already have 18 EU member states having joined. Back to the advantages. You see them here on the right side of the screen, on which I will focus. The unitary patent is registered by the EPO in one single step. It provides uniform protection in the 18 participating EU member states. A significant advantage is that there is no need for multiple, parallel, costly national validation in the different states where the patent proprietor wants to have patent protection. So again, one single request to the EPO and one procedure at the EPO to obtain a unitary patent. Also here an overview of the advantages on the right side compared to the what we now call the classical European system, where often several translations were required, national validation fees had to be paid. So all sort of different national red tape before a European patent could become valid in the different states. By contrast, today, on the right side, the unitary patent registered by the EPO in one single procedure with a simplified translation regime, no fee payable to the EPO for obtaining the unitary patent, one set of renewal fees during the lifetime of the unitary patent, one currency, one register maintained centrally by the EPO. Here more details on the reduced cost of the unitary patent. Let me focus perhaps on the second point, the attractive fee level, the renewal fees for the unitary patent, which have to be paid to the EPO directly. If you maintain the unitary patent for a period of 10 years, the renewal fees for these years will be approximately 5,000 euros. Also here, to be compared with national renewal fees payable to national patent offices for maintaining the classical European patent in the national states of the EPO. I have here the statistics to show the very successful start of the unitary patent system. It's taken yesterday from the unitary patent dashboard maintained by the EPO, showing how many requests have been received, how many unitary patents have been registered, from where, the technology fields, and the uptake rate. And you have here 3 screenshots showing the total number of requests for unitary patent filed at the EPO since the start of the system in June 2023. So we are at a little more than 67,000 requests for unitary patents. And you see that almost all of them are registered by the EPO. So once again, once you have obtained a European patent at the EPO, so after the patentability requirements and other formalities have been checked by the EPO, the inventor now has a European patent, and if he makes use of the option, if he requests a unitary patent, you see that it's only a formality to obtain such a unitary patent by the EPO, covering 18 EU member states. Below is the steady increase in the number of requests. Almost 40% of all European patents granted today by the EPO are becoming unitary patents. There is also a map on the dashboard where you can see the geography of the unitary patent, and with the mouse run over the countries. And of course, there is the concentration: Europe, US, Korea, Japan, China, but also almost all other countries of the planet have a few unitary patents registered so far. And it's always entertaining to see Egypt, Kazakhstan, everywhere the unitary patent is now in use. I have little time to say much about the compensation schemes for SMEs having their residence principal place of business in an EU member states, filing the initial European patent application in an EU official language other than English, French, or German. They may obtain a compensation of 500 euros. Here's a list of the other more general benefits of the unitary patent. I think this will be part of the discussion later on. So maybe just the keywords here. If you have a unitary patent, it's much easier to secure investment. The high quality of the unitary patents, which are based on European patents, confer uniform protection in a much larger market than national patents or even European patents validated only in a few member states. More readable for foreign investors looking to invest. Fourth point, the internal market. This is all about the internal market, making inventors to understand that there is much more than just their local national market. There exists today much wider possibilities in the EU. Today already for 18 states, soon hopefully for all EU member states. And the possibilities here are if the unitary patent has been obtained, are really tremendous compared to the classical European patent valid only in a few states. A central register where maintained by the EPO, where all the information relating to unitary patents are collected, recorded, maintained up to date. Also here, of course, a huge difference compared to the past, where such information had to be found in national registers. We come finally in the last 5 minutes to the Unified Patent Court, which could certainly be the subject of an entire seminar of several days. So I only want to make you aware of the possibility to better enforce your patent, both the classical European patent, if you have one, or the new unitary patents. The enforcement possibilities have much improved with the coming into existence of the Unified Patent Court. In a nutshell, the new court is a new international, supranational European court with jurisdiction for infringement and revocation of both the new unitary patents and the classical European patents. We have specialized judges at the UPC, and they are applying their own procedural law. All decisions of the UPC are taken by judges of different nationalities, and most importantly, both legally qualified judges and also technically qualified judges are participating in these decisions on infringement and validity of patents. The benefits of the new court are listed here. The aim is to establish an effective forum for enforcing challenging patent rights in Europe. The situation we had in the past with sometimes several parallel national proceedings going on before national courts will gradually cease in the coming years, insofar as such litigation will be centralized at the new Unified Patent Court. This is good for legal certainty, with slowly now a harmonized case law developing on infringement and validity questions. We see already the first signs that the UPC is a simpler, quicker, more efficient judicial procedure compared to these national differences between many member states. The UPC applies final advantage. The UPC applies a uniform substantive patent law on the scope of the rights conferred by the patents and their limits, and shared remedies in case of infringement. I do mention here that we are still in a transitional period of 7 years, where there is the possibility to escape from this new court in case the owner of a European patent does not want the new court to hear litigation. There is a possibility to opt out. So that's described here in the fourth bullet point. The applicant, the proprietor, of a European patent or a supplementary protection certificate may opt out from the exclusive jurisdiction of the UPC. The language of proceeding deserves a mention, I think, only for perhaps for the first bullet point, insofar as the official language of the proceedings before the UPC will often be the language of the plaintiff. So the local division of the UPC situated in Helsinki will hear cases in Finnish. There is then, of course, possibilities to have the translations, simultaneous interpretations, but there is no risk to have to deal with other languages than your own before the UPC. Representation is mandatory, and so a party starting an infringement action or a revocation action must be represented by either a lawyer or a European patent attorney with additional appropriate qualifications. A word about the fees payable to the UPC. There is a fixed fee for starting the action before the UPC, and there may be an additional value-based fees for cases with a value over 500,000 euros. There are some examples here, and at the bottom, 11,000 euros for starting an infringement action may sound as a lot of money, and it is certainly. On the other side, this is litigation between businesses, the patent proprietor against another company alleged to infringe the invention. So the fee is one aspect. The other aspect of the cost are the attorney fees, so the cost of representation. There are support schemes for SMEs in relation to these court fees, with reductions, 40% for SMEs and micro entities, 25% if a single judge is hearing the case. And also below here, some possibilities for reimbursement or legal aid. I think that brings me to my last slide, which is really some sort of pro and cons of the new system. New choices have to be made by patent proprietors. I'm sure the discussion will come back to some of these aspects here. So only very briefly here, a new choice to be made between either the old classical European patent and the new unitary patent. The new unitary patent offers protection in 18 member states, one-stop shop after grant, and protection at the external borders of the Union. The classical European patent will probably continue to exist for some years, some decades still. It does still have some advantages insofar as the patent proprietor can decide freely to validate, maintain, enforce the European patent country by country. Second aspect of this list of pros and cons, in case of litigation, it's extremely rare, but in one case out of 1,000 approximately, a patent gets involved in litigation, and this may be either before the UPC or before national courts. If the patent proprietor opts for the unitary patent, then all litigation will automatically go to the UPC. By contrast, if the European patent is chosen, then there is a choice between either the new EPC or the national courts during the 7-year transitional period. Let me finish here. Thank you very much for your attention, and I remain in the call for questions or discussions. Thank you very much.
Thank you very much, Eskil. So I will jump in now. My name is Adéla Dvořáková. I work at the EIC, and you were actually supposed to see me a little bit later in this training. But because we have lost our moderator due to technical issues, I will jump in and ask Eskil a few questions that we got from the audience. I think we have time just for like 2 questions because we are a little bit over time. So Eskil, I would like to ask you, you talked about the transitional period in which it is possible to opt out from the jurisdiction of the UPC in case of the classical European patents, let's say. Could you share with us, or would you know what is the status of the negotiations regarding the extension of this transitional period? Do you think that it's likely that it's going to be extended, or is it not yet decided? Would you have any insights on this?
Thank you very much. The system is 2 years old. The transitional period is 7 years. So no, definitely no. The reflections, the analysis of the situation in relation to the extension of the transitional period have not started yet. And what we can say is that the beginning of the UPC has been a huge success, measured in the number of cases. On the other side, definitely users appreciate this flexibility. Mm-hmm. So continuing to have the option between going to the national courts or choosing the new UPC. The possibility to extend exists once. So we have 7 years, we could have 7 years more. And in any event, it would be the end after maximum 14 years.
Mm-hmm. Okay, thanks a lot, Eskil. And maybe one more question. So you mentioned the compensation scheme for SMEs. And we got a question from the audience that maybe it was a little bit too quick on this aspect. This is something that is very relevant for the EIC beneficiaries in particular, that are very often startups that are, let's say, tight on budget. So they would like to always know about these possibilities to get some discounts or compensation. Could you maybe explain it a little bit better? And then there's an additional question actually from my side. I know that there are also some additional discounts that the EPO gives to micro entities. So maybe if you could also tell us a little bit about that. What do these discounts actually apply to and who is eligible?
Yes, for sure. Thank you. The compensation schemes, you need to be aware of this at an early stage indeed, because it concerns the filing of the European patent application. So it's really at the very beginning of the process when you decide to file a European patent application at the EPO. You may do it either in one of the 3 official languages of the EPO, or if you're domiciled in a country like Denmark, Sweden, Finland, not having one of the 3 official languages of the EPO as an official language, so Danish, Swedish, Finnish, then you may file the European patent application in Danish, Swedish, or Finnish. And if you do so, then there is a possibility first to get a refund of the EPO fees at the beginning of the EPO phase of the search examination process. Mm-hmm. And additionally, and that's what I refer to as a compensation scheme, if later on, and here we speak 4 or 5 years later, when you have obtained the European patent, if you then decide to opt for the unitary patent, then there is this possibilities, again, for SMEs, universities, non-profit organizations, to obtain a compensation of 500 euros.
On the translation fees, right? Or on the translation costs, I mean.
Yes.
Yes. Okay, very good. Thanks a lot, Eskil. So with this, I will hand over to Thomas Bereuter so that he introduces our next speaker.
Thank you, Adéla. Thank you, Eskil. So now we are well equipped with some of the fundamentals of the European patent system. Let's take on a more tactical and strategic approach. As we have just heard, the unitary patent essentially is a new and additional type of patent protection. But whenever there are different options, you have to make informed decisions. And thankfully, we have Martin Wilming with us today, who will now tell us a bit more about why patent protection tactics and strategies matter. Martin Wilming is a Swiss and European patent attorney with a PhD in bioorganic chemistry. He is a member of EPI's European Patent Practice Committee and the Standing Advisory Committee before the EPO. Martin is also one of the founding fathers of I3PM, the International Institute of IP Management. So Martin, up to you. Thank you.
Thanks for the kind introduction, Thomas. It's always a pleasure to follow after Eskil, because almost all questions are already answered when you follow after Eskil. But still, there are maybe some things that I might add to what Eskil already said. So what you see on the screen is the title of the presentation. I was asked to expand on this topic a bit. And well, that's a topic that is very much to my liking, because it's really, or my interpretation of that part is to color the picture a bit for you, and to, yeah, as we are talking to business people, really to show you some practical examples of what you could do with that in practice. So it's all about patent protection strategy. Now, when you ask people about their strategy, they always tell you they have one. And when you then dig a bit deeper and you open this strategy box, then you sometimes doubt they may have some management plans, how they want to handle their portfolio, but sometimes it's not so clear whether there is a real strategy. So different people understand different things when it comes to strategy. Here are just a few buzzwords. My favorite definition of what is a strategy is this one: the art of devising plans towards a goal. So in the end, there must be a goal, what you want to achieve in terms of business. And then you need to have a plan, how you get to this goal, how to execute it. Some might call it tactics, but here it's in this definition, it's a plan. And all this together is an art. It's not just something that works for in every situation, something you just can execute. It's an art to devise a strategy. That's my point of view. Now, as I said, I wanted to color the picture a bit. Now, imagine it's a case study that I really made up. Imagine a world with this luggage porters some 50, 60 years ago. That's an image courtesy of Lufthansa, when we still were living in the time where we all still carried our luggage by hand. And now put yourself in the shoes of a leading high-end suitcase manufacturer, you name it. And you have invented a suitcase on wheels. Great thing. And you managed to get a European patent granted for it. So that's the setup of the situation. Will you choose the unitary patent in such a situation? You see a bit blurry in the background again, the countries that are reachable via this unitary patent protection in one go as a package. As a leading, well-renowned brand for suitcases, will you go for the unitary patent or no? Well, considerations might be the following. The pros are definitely more countries for less money. That's easy, and everybody wants that. That is definitely a pro. And then you might also think, well, it's a totally new product segment that creates business opportunities in previously unserved countries that are included in this package. Why not? So those are definitely pros. On the other side, the cons, you might well face exposure from previously uncharted countries, those countries who were not willing to pay for your high price suitcases before. All of a sudden you appear with a patent on the on the table of your competitors, potential competitors in those countries. And then, as Eskil already explained, then you have almost all eggs in one basket at the UPC. If someone from these countries challenges your patent at the UPC, then you will lose a patent for all those countries that belong to the unitary patent system. That is what I mean with all eggs in one basket. So one consideration will definitely be, is the patent strong enough to withstand whatever you could think of a challenge to this patent? Those are the exposures from previously uncharted countries where you may have not so much experience from your business before. But there is also exposure in previously uncharted countries when you all of a sudden start to market a suitcase on wheel in countries where you had no previous exposure, then you might out of a sudden be challenged with respect to your freedom to operate. And it's not a major topic of today, but I will briefly explain what I mean by that, a word on freedom to operate. Again, think of the suitcase on wheels. What is a suitcase on wheels other than a vehicle? Okay, it's a human-powered vehicle, but it's still a vehicle. It's something on wheels. You have maybe never thought about any patent that could be could be a bar to your market approach. You never thought about patents that might hinder you to market your suitcases because you simply did not produce any vehicles. But since you now put wheels on your suitcase, you may well be challenged from such patents. So a vehicle is nothing more than a conveyance moving on wheels, like a cart. So I would say you might out of a sudden be faced with patent protection for some vehicles. So whenever you step into a new market segment, and in particular to countries you have no experience in, which might be included in this unitary patent package, you should also at least spend a thought on FTO aspects. Now, let's twist this example a little bit. Imagine again a world where we still carry our luggage, but you are someone different, just a bright mind with limited financial resources, like me or you, like every natural person. You have invented the suitcase on wheels again, and you managed to get a European patent granted for it again. So will you now choose the unitary patent? And the approach to this question as a natural person with limited budgets might well be different. The pros, more countries for less money, that remains unchanged, I would say. And another pro is, hey, there all of a sudden are a lot of licensing opportunities. You might not be in a position to practice your invention in each and every country, but you might potentially find licensees in all these countries that are covered by a unitary patent. So yeah, this is definitely a pro. On the other side, the cons again, exposure from uncharted countries, all eggs in one basket at the UPC. If you think of that, well, it's not ideal, but in your situation as a natural person with limited resources and weighing the chances of obtaining license fees potentially from those countries, it's not ideal, but it's definitely acceptable, I would say. And exposure in uncharted countries, freedom to operate, we just had a look at that one. Well, that can definitely be dealt with in license contracts. If you have a licensee practicing the invention in those countries, if the license contract is drafted properly, then it's pretty much not your problem. So the approach to the pros and cons for a unitary patent or against a unitary patent may change dramatically depending on your situation. Natural person via well-renowned, highly profitable suitcase manufacturer. That's a picture, all eggs in one basket, obviously. that's not the case. All eggs in one basket, not necessarily, and I will show you why. So Eskil already explained, there is also a system of national applications only, without any European patent, without any unitary patent, just national applications. It's a very old-fashioned, but it's still a valid approach that some people take. You can file a national patent in Germany, you can file a national patent in Switzerland and Liechtenstein, and there are definitely pros for that. It's very cost-effective for a very small set of countries. Here in this example, it's all in the same language. You only have 2 countries. You don't even need a European patent, not to mention a unitary patent for that, if you are very sure that these are the only countries you would ever want to reach. But who is that? Not many people nowadays. But it's still a valid approach that one at least should have on the radar. On the other hand, the national applications are almost unpayable by anyone for a larger set of countries, because then you have to go for each and every jurisdiction and have to go through examination in each and every jurisdiction, which is just a pain in terms of costs and time and management efforts. If you have more than 2 or 3 countries, you would never do that. So, yeah, that was what I already mentioned. Then the Euro-direct application tactics, filing tactics, that is also something that Eskil already mentioned. You make a European filing, you go through examination, the patent is granted at one point. The pros for that are definitely that it's very cost effective. If you already have to cover more than 3 countries, then there is the break even where a European patent application is definitely cheaper than the only national application strategy. And quality, I'm a big fan of the European Patent Office in terms of quality. The cons, obviously, none in my mind for 3 or more countries in Europe. So Euro-direct is definitely the way to go for more than 3 countries. But what happens after grant? After grant, you can go for this unitary patent in these 18 countries. But there may well be countries that are not reachable by this unitary patent package, like the UK or Switzerland, where I am based. But that doesn't matter. You can add them on top of the European patent and you get them in parallel. You just do, in parallel to the unitary patent, also a national validation in the UK and Switzerland, and you're fine. So that's the next strategy, or filing tactics to be precise. And what Eskil also mentioned is the PCT phase. And just to color that picture a bit, you start with a PCT application here. That is an international phase that lasts, well, extremely long, 2.5 years actually. And only after 2.5 years, you need to decide where you finally nationalize or regionalize your international patent application. And here I gave you the example that you made the decision to go for a European patent application. And again, after the examination, it is granted. And yeah, the pros, again, the PCT stage, well, it's a kind of worldwide option for patent protection. Whenever you read in the media, there is a world patent. Don't believe in that. There is no world patent. It's just a worldwide patent option, an option for patent protection. And that essentially buys you time in order to make up your mind where you definitely want to have patent protection. And costs are deferred, which is something that businesses definitely like, typically. I do too. And the cons, it's delayed examination. Some say delayed examination is also a disadvantage. I can't see that. I like to defer examination in by far the most of the cases. So, and again, after the European patent grant, you can go for the unitary patent and add whatever you like as countries in parallel that you cannot reach via the unitary patent. That is a topic now, multiple revenue streams, that I always find a bit interesting. And Csaba will present a case study later, and I stalked him a little bit and his company, and I think it might even be a topic that he has or had on his mind, because in the sneak preview that I will now be giving you, that is a video that I have stolen from eChemicles website. What they are doing is they have a process using some hardware, which is a green box in the middle that now starts doing things, and it's as an input, it has CO2 from CO2 emitters. It uses renewable energy. And in the end, it produces carbon monoxide, syngas actually, that can be used in the production of steel and chemicals. And it produces ethylene in the bottom right that can again be used in order to produce chemicals and fuels and plastics and so on. So when you look at this video, there are definitely various revenue streams that you could think of. You could collect money from these CO2 emitters in order to collect the CO2 from them and make it usable. And you could also sell the syngas and the ethylene to the users on the right side of this video that you have just seen. And another thing in that setup that Csaba will definitely tell you more about is there's hardware involved and specific method items. And Eskil already explained, you can have patent protection for things, hardware, classical hardware, machines, containers, whatever, and methods, which are just defined as a sequence of steps of doing certain things. So whenever you have these two categories of patent protection, you could draft an independent claim on that. Now, how you could use the various filing tactics in order to cover that, I will give you an example here. You could file a first European patent application, let's say, for the method, for the production of the syngas that can be used in the production of steel, for instance. And you go for a unitary patent for that method. And for instance, your line of thinking is, well, that method can be used almost everywhere, and I want to have protection in as many countries for as little money as I can think of. Then you would definitely go for the unitary patent, and you again may opt for UK and Switzerland on top of that. And for the hardware, you could maybe think, okay, it's a system, it's hardware. There is not many countries where this hardware can be really reliably and with high quality produced. And I want to be sure that this patent is not exposed in countries which I don't need actually for that. And then your approach might be different. You might say, okay, this system, this hardware will, with a high likelihood, only be produced in Germany, France, and Italy. Then you only go for these countries. You take the European patent and validate it in Germany, France, and Italy, and there you go. You have no exposure from the other countries that form part of the unitary patent package, where you really don't see any need for that part of your invention, which is a hardware. That could be a line of thinking that in the end ends up to a different approach for the hardware compared to the software component of your invention. When you ask an inventor, they always say, oh, I made one invention. This is my invention. The patent attorneys, when they come into play, they see a multitude of aspects of this invention. And one, for instance, is the hardware, and the other aspect is the software, or the method here, not the software, the method. And then you could easily separate that right from the beginning, as I did it in this example. But you could also do that while you are still in prosecution. Here is again the string with the European first filing. It proceeds to grant with the method claims, and before grant, you just file a divisional application based on what you had written in the specification of your first filing. You file a divisional application, EP2, during prosecution, and then make a second European filing out of that and move to grant with the system claims and follow the exactly same strategy that I have outlined on the slide before. That could be just another another filing tactic. Just start with one application and file a divisional application during prosecution later. So wrapping up all the options, I'm not sure if I covered all of them, but at least some of them. What can you do? There is definitely not a unitary patent alone, and not everyone needs to jump 100% on a unitary patent. It's a great option. I today like it very much. Maybe in the Q&A I can explain a bit more on what changed in my view over time. But again, what can be done? First option, national filings only, very old-fashioned. Only national validations of a European patent, ignoring the unitary patent option. Then you could do unitary patent plus national filings in parallel, unitary patent plus divisional EP validated nationally, and so on. You can read it for yourself. There is a lot of options what you can do now, and the unitary patent is just another tool in the toolbox, a very great tool, which I really have to admit, it's a great tool, but it's just a further tool. The ultimate strategy, if you expected me to come up with the ultimate strategy, I'm sorry, but there is no one-fits-all strategy. I hope I have outlined some of the lines of thinking that I would think make sense, but there is no one-fits-all strategy because all applicants are different. They are having different setups, different target groups, in terms of customers, in terms of competitors, in terms of markets. So yeah, the ultimate answer, I don't have it, but I hope I could give you some food for thought. Thanks for listening. That was my fun part to color the picture that Eskil already prepared for me.
So thanks again, Martin, for this very insightful overview of the different options that we have. And as you just clearly or made clear, unfortunately, there's no one-fits-all solution or strategy, as you said. And it must be defined in accordance with a specific business case or project and aligned with your goals. And as you already presented a kind of teaser to the next speaker and to the case that we now hear more about, so we're going to do exactly that. We're going to zoom in on a very concrete case. In this case, we will hear about the EIC transition project Solar CO2 Value, and the Hungarian company behind it, eChemicles. And I already see that Csaba Janáky has already switched on his camera. He is the co-founder and chairman of the board of eChemicles, and we're excited to hear a bit more about the particular journey of this project and also the strategy that you chose. And Martin will join us then later on for a Q&A together with Csaba, and Adéla Dvořáková from the EIC might comment as well. Thanks.
All right. Thank you very much, Stephanie, for the introduction. I hope you can hear me. So it's my great pleasure to give a quick snapshot on what we do at eChemicles and what we have done within the framework of this EIC transition project, where we developed the world's first containerized low-temperature CO2 electrolyzer system. This was awarded recently by the World Economic Forum by a top innovator status, and we also entered into a strategic partnership with Bosch in scaling this technology further. So as we are at an intellectual property workshop, I need to clarify that Martin has not stolen that animation, what he has shown. So he had our consent to present that animation. But again, briefly, what we do is we work with captured CO2 from industrial emitters and use renewable energy to convert that captured CO2 to platform molecules, most importantly, carbon monoxide and ethylene, which can be used on the downstream by various hard-to-abate industries. So basically, we are killing two birds with one stone, replacing an existing fossil-based production process and also using CO2 as the feedstock. So we are very much an R&D based company. So IP is really in the core in our activities, also to keep our technological advantage over our competitors. So our IP is a mix of patents. They are mostly focusing on the electrolyzer stack, the system around it, and the process, how it works. We have trademarks, both on company name and also product name, and a lot of trade secret regarding catalyst ink formulation, coating process, how we operate the system in terms of logic. The other thing, what is very important to highlight, that we have 4 different types of key stakeholders regarding IP. So we have the inventors within the company who basically suggest possible new inventions which are invented during our activities, and what are those engineering solutions which should be protected. We also have a part-time internal IP expert who breathes with us, basically, and she analyzes these prospective inventions and outlines what kind of opportunities, what kind of directions, tactics we can take as the next steps. And at this point, we talk to our external contracted IP law firm partner, who is a strategic partner. We have been working with them for many years now. And they do some calculations for us to estimate how much the different directions would cost throughout the lifetime of the patent. And then the founders or the management of the company makes the decision, and then this contracted law firm is starting the administrative actions together with our people. And if we focus more on the patents themselves, now we have 5 patent families. The first 2 are the ones on which the company is based on, basically, and these were pre-EIC transition project, one related to the electrolyzer stack itself, and the other one related to the process. And according to the qualification, what Martin was showing, this is the Euro PCT direction, basically. So we started with a PCT, then went for a European patent, and also other geographies around the world. And for the second one, actually, as the EPO granted the European patent, recently this year we entered to the process, or we filed for this unitary patent protection. We don't know how we'll go with the first one, we'll see. And the 3 others are new, so they were filed within the past 1.5 years. Here I would like to mention one more thing. So the EIC is providing different services also through their Tech to Market venture building program. And for example, we were privileged to get this support regarding obtaining a freedom to operate analysis based on our first 2 patents that time, and also the competitive landscape. And they really provided a high quality, in-depth report, which is not necessarily the case for all FTOs. And so a personal take on why unitary patent, and it's really how myself, not being an expert in IP, see this, is that clearly what was told before by the esteemed colleagues, it's beyond any doubt that it's simplified administration. So there is one single system, one single validation, one management. It's cheaper, which is obviously in one one very decisive factor in the process, and also the high quality litigation is provided through this centralized unified patent court. Of course, there is also a why not, and it's a typical response of risk sharing or diversification. So we don't want to put necessarily all in one bet. Because then if the patent fails for any reason, then it fails everywhere in Europe. And if we go through the validation, through the national routes, that allows a certain level of diversification. Actually, some of our partners and the investors also indicated an interest or suggestion to go through also the national phases to be on the safe side, at least for the most important patent we have. So with this, I would like to thank you for your attention, and I'm open for any question.
Okay, thanks a lot, Csaba, for this really insightful presentation. And also thanks to Martin for setting the stage so that we can zoom into your specific case. So from the point of view of the EIC, I would just like to highlight that your project actually is considered to be very successful at the EIC transition. It just recently ended with very good results. And one of the reasons why we consider it very successful is actually what we have just seen in your presentation. Because one of the main objectives of EIC transition is actually to make our companies or our beneficiaries investment ready and to increase their business readiness level. And IP is definitely one of the core elements in that whole process. And I think I can speak for all my colleagues if I say that we would actually like to see what we have seen in your presentation at the end of every transition project. So really, congratulations on that.
Thank you.
And I would like to ask you a couple of questions. So we have seen in your presentation that you have actually quite an elaborated structure of how you manage IP. So you seem to work in a very organized manner. You are also yourself involved in the main decision making and so on, and you aim at making informed decisions, which we clearly have seen in your presentation, and which we always recommend to our beneficiaries to really gather all the information to make informed decisions. And you also seem to have a lot of knowledge yourself on IP. So my question would be, how did you get all that knowledge, and how did you learn all that you apply now in your company? So was it a little bit of trial and error, or did you learn from someone or from previous experience?
It's actually both. So it's I would lie if I would say that it was this streamlined from the very first moment. So obviously it was not. So for example, when we had those PCT patent applications at the time when we applied for the transition project, I would never thought that we'll have more work with those applications in the coming years than with the new ones. And we had a lot to do with all the regional, national, European, whatever applications. So that's something which we learned on the fly. On the other hand, I'm also a university professor, so it's basically I had some experience before internally, but what I've learned during these years is that it's very different to take a decision where I really need to analyze the financial implications of the decision, and that's why it's very important to analyze how much it's going to cost throughout the lifetime if we take route A, B, or C, and then we need to balance between there is a certain risk, but okay, then the cost is that. So that's something we really learned, and what I also learned that it's very useful to talk to patent attorneys. Because initially we spoke a very different language, I would say. So when we discussed about these questions, what is a strategy, what is a tactique, how about protecting process, how about the system, the instrument, then how about the geographies, it was quite blurred, I have to admit, even for somebody like myself, who I was involved in these kind of things before, and really discussions and discussions with them really helps. Of course, hourly rates are not low for patent attorneys, so these discussions should also be quite efficient and effective, but that's necessary. So.
Yeah, indeed. I think that's important what you just said. You should
and also maybe one more thing. So having somebody part-time with IP background at the company, that really helps. And of course, small companies can't afford to have somebody, full-time. But even if somebody is there, in our case, with like 0.2 FTE, that really helps in a sense that the person knows what's going on. So she is an internal person, and she really knows in depth what's happening and can act as an interface, a daily interface with the external attorneys.
Yeah, thanks a lot. Yeah, I would just like to highlight one thing that you said. You said that you need to be prepared for the talks with the patent attorneys, because indeed their hourly rates are quite high, and you don't want to waste them in a not wise manner. So that's actually one of the objectives of these trainings that we give, to give information, to teach people the basics, so that they have then everything ready for the efficient talks with the patent attorneys. Indeed. Regarding the internal IP expert, let's say, or somebody who is dedicated to that, at what stage of your company did you actually hire that person? Was it right at the beginning, or how old was the company when you got such a person on board?
No, not at the very beginning. So basically, once the first private investment was secured. So that was the point when we recognized that it's very important, and it's going to be even more important during the subsequent investment rounds, that we need somebody who is taking care of this.
Mm-hmm. Okay, thanks a lot, Csaba. I would have a lot more questions to ask you, but for the sake of time, I will now, I'm turning myself to Martin, who is also with us at the moment. Martin, I would also like to ask you a question, because you are a patent attorney with a lot of experience with the Unitary Patent, and we are here talking in front of a lot of young companies and startups. And I would like to ask you, well, at the beginning of this system, when it all started, there might have been maybe a little bit of fear and skepticism if that's really going to work for small companies like Csaba's company, for example. Could you tell us from your experience as patent attorney how that actually turned out, if the system really is serving well these small companies, and if the uptake of the Unitary Patent is high among them?
Oh, I can tell you by heart, definitely, because I have been very skeptic in the very beginning of the Unitary Patent Court and the Unitary Patent. To say that upfront, I'm based in Switzerland. I'm a German guy living in Switzerland. Meanwhile, I'm Swiss, but from Switzerland, we are an outsider. So the Unitary Patent System for us is a foreign system, and the Unitary Patent Court is a foreign court. So, and this Unitary Patent did not come out of the blue. It was discussed for decades. And if you had asked me 5 years ago, I would have said I will be retired before the Unitary Patent comes into effect. So, and as a patent attorney, I'm in a way trained to be risk averse. I cannot gamble with the IP rights of clients. So I'm trained to be risk averse, and I'm trained to, well, hope for the best but expect the worst. And when you see a new court that is being built up, how would I recommend a client to just jump on it and be the guinea pig for the very, very first tries of a new court system? Just wait and see and look how that develops. And I was skeptical, to be very open, and I'm meanwhile 2 years down the road pretty amazed. They are doing an extremely good job at the UPC. And when you look at the names of the judges, there is no wonder why, because those were the best national judges that rendered the best decisions in their countries. So, well, no wonder they are rendering good decisions at the UPC now. So I'm really amazed of this new court system, and all my skepticism has almost disappeared. So from our clientele, we are not representing these huge, big multinationals with hundreds of patent applications each year. We are more representing these small, medium enterprises located in Germany, Austria, Switzerland, France, the area around us. And almost all of these clients, meanwhile, go for the Unitary Patent in by far the most cases, I have to add. Not at 100% rule, but in by far the most cases. Because, well, meanwhile, I feel confident enough to recommend them doing so.
Mm-hmm.
It's as simple as that.
Indeed, that's very interesting. Well, we talked a lot here about the risks associated with, let's say, the threat of having all eggs in one basket and having that patent invalidated in all countries at once. But that also has like a positive implication, right? That there is only one legal proceeding for every single matter related to the Unitary Patent. So can you elaborate on that? What are the advantages then in practice?
Exactly. There is always an offensive and a defensive side to a patent. If you want to enforce your patent and you have a Unitary Patent, then you can enforce it in one go with effect for 18 countries. And without a Unitary Patent and the Unitary Patent Court, you would have to go through all these 18 countries until the public finally believes that this patent is really valid and infringed. So that can save you a lot of money in terms of enforcement. And on the defensive side, if you are faced with a nullity action at the Unified Patent Court, then of course your patent might also be invalidated with effect for all these 18 countries. But that again is a kind of risk evaluation that every applicant needs to make for himself. Do I trust in my patent, or have I been more on the lucky side with the examiner that this patent finally proceeded to grant, and you did not even believe it yourself that you were so lucky to get this patent granted? If it's a weak patent, I would still think twice to go for the UP. But if you have no reason to doubt the validity of your patent, then why not? The pros definitely outweigh the cons for me.
Okay. Thanks a lot, Martin. That I think that we already are running out of time, or we have run out of time. So before maybe allowing Stephanie to ask a few questions from the audience, would you like anything to add, or would you like to wrap up to close this part of the case study?
From my side, I will leave it at that for the sake of timing. Thank you.
Then I will give the word to Stephanie to see if we have any questions from the audience.
Yes, we have. And I think a very common question, to be honest, is that startups often have limited resources. Csaba also touched upon it. And there's a question, what are the pros and the cons of keeping know-how secret rather than getting involved with the entire patent system? And Martin, what's your perspective on that and your recommendation?
Well, relying on trade secrets is again a risk evaluation. As long as you manage to keep your trade secret, you're on the safe side. But as soon as your trade secret somehow gets revealed by accident, employees move and they talk, and you will never be in a position to really prove that someone has talked, and somehow the knowledge got into the outer world, then the knowledge is gone. You have no way to get it back. The patent system is a way to have really a right in your hand that runs for 20 years. Whatever happens and who is talking about it, it's just what is written is safe for 20 years. The claims are secured for 20 years. And of course, if you have no resources to go for patent protection, you have no other choice to go for a trade secret. But be aware that there is I tend to recall a study that the half-time of trade secrets is no longer than 5 years, just statistically. And well, that's not much. A patent has 20 years. And the other thing is, trade secrets only work for things that are not revealed when you bring your product on the market. When you bring your product on the market and it can be inspected by the public, then it's not a trade secret anymore. You can hold internal things as a trade secret, or things that cannot be inspected on the actual product that is on the market. But for anything that can be seen in the product, there is no way to protect it as a trade secret.
Csaba, you want to add to that? I see your hand raised.
Just very briefly, that for the exact reasons what Martin said. So if you want to raise money from investors, and those are qualified investors and they know the field, they will very carefully analyze the IP. I mean, it's without that, especially at a stage when a company is not generating revenue yet. So what can be the basis of the evaluation? The maturity of the technology and the strength of the IP. And in that, it can really boost the value of the company. If you have, it's also a must to have some, but if you have good quality IP background, that will really help to have a good valuation.
So we've heard a lot about different options, about different strategies and potential routes that you may take in terms of patent protection. And now we add even more to that. Our next two speakers will explore a bit what additional options and best practices there are for patent protection and also licensing agreements. And they will help us navigate the seemingly intricate waters of different filing strategies. But the good news is they also will share some very useful and hands-on tips. And as said, will delineate some of best practice cases and scenarios. So it's my pleasure to introduce you to Mariella Massaro and Robert Alderson, two highly experienced IP professionals and partners at Berggren, a leading internationally widely awarded intellectual property expert organization headquartered in Helsinki, Finland. And maybe just one comment before I pass the mic on to Mariella, who's already here with me. Mariella and Robert also co-authored a very insightful article, which was published last year in Les Nouvelles, the magazine of the Licensing Executive Society International, as many of you will know. And we'll also share the link, or you'll find that in the course room where we'll provide additional resources. And with that, Mariella, very welcome to this virtual stage, and the floor is yours.
Thank you, Stephanie. So Mariella and I will kind of take two different topics. I will speak a little bit about some of these other sort of combination strategies. As Martin said, it's easy to follow Eskil when he's already kind of laid the groundwork. It's even easier to follow both of them. And as Csaba, and even more so as Csaba gave some examples of how you can do different strategies. So with that, we will continue. By the way, as Mariella is driving the slides, I'll just say that I'm both a US and European patent attorney and a qualified UPC litigator. So we'll talk about strategies for building a robust portfolio, but just to sort of level set, and we've already heard from previous speakers how this normally works, but if you kind of put it all in one slide, don't be frightened by all the arrows. I will break this down for you very quickly. If you look across the top level, you see that these options happen after a European patent application has been filed, and then you've reached the grant phase. In the typical way of getting a classic European patent, you have 3 months after grant to decide which countries you want to validate in, and so you select those countries for national validation, and those types of patents or those validations are covered by national courts. There's an exception to that, and I'll get to that in just a second. At the very bottom, you can see that after grant, you have 1 month to request unitary effect if you want a unitary patent, and unitary patents are always subject to the jurisdiction of the Unified Patent Court. During this transition period, there will be, for UPC countries, there will be parallel jurisdiction between national courts and the Unified Patent Court for classically validated European patents that have not been opted out of the system. We heard a couple of words about opt-outs. If you can opt a European patent, a classic European patent, out of the jurisdiction of the Unified Patent Court, and that it will be subject only to the national court jurisdiction. So that's a quick level set and recap of how the different court systems interact with each other in this transition period that we're in now. So what are some of the pros of a unitary patent? Well, as we've already heard, it has broad geographical coverage, currently 18 EU member states. The cost is low if you plan on obtaining coverage in a number of different countries. The enforcement at the Unified Patent Court has been shown in the first 2 years to be very efficient and simple. The decisions are extremely fast. We have seen UPC decisions issued within 1 year of the statement of claim being filed. And normally it's sort of 12 to 14 months, but we've actually seen faster than 12 months. And if there's the need for urgent proceedings, you can even get a preliminary injunction, let's say at a trade fair, for example. And the cases are handled by very experienced judges. And I might want to say here, before we switch slides, that a recent Court of Justice decision actually extended the long-arm jurisdiction of the UPC to cover non-UPC member states like the UK, Switzerland, and Spain, if under the right conditions. So it's kind of interesting to see that for the court, the territorial extension is a little bit more than the UPC countries themselves, or can be. the pros of a classic European patent include the following. If you're only interested in a few countries, and for example, Germany, France, and Great Britain are the most common combinations that are selected. If you're looking just at cost, and I think one of the questions that we had in the Q&A was, how do you decide which one to do? If you're just looking at cost under these conditions, it would be better to just get a classic European patent. It's also possible, it's more flexible with respect to renewal fee payments, because you could drop one of the countries, say France was not important for your technology. After some number of years, you could drop the French portion of the patent out and only pay for Germany and Great Britain, for example. And it's more difficult for third parties to invalidate the patent if they have to go country by country on an opted out classic European patent that's not subject to the UPC jurisdiction. So sometimes when we're asked about which kind of patent you should get, a unitary patent or a classic European patent, the either or decision may be, we might even look at it as, under some conditions, a both and proposition. So we're going to look at a couple of different ways to combine IP protection to layer it and to have more protection than you would have for a, let's say, eggs and all in one basket issue to prevent that. So we heard a little bit about national patents, and this is an example of how we can combine a unitary patent and a national patent. Let's say you have in this example, a PCT application that goes to a European regional phase where you, once after grant, you get a unitary patent. The PCT application, you can also file a German national phase and have in parallel a unitary patent and a German national patent with the exact same claims. And this is also available in other countries, and we'll show you in 2 slides from now which countries allow this exact way of proceeding. So diving in a little bit deeper into the combination of a unitary patent and a German national patent, one of the advantages of doing this with Germany is that in a German national patent, the examination requests can be delayed for up to 7 years from the filing date. So in this case, you have time to let the European prosecution take place, get your grant, get a unitary patent with a certain claim set, and then file request examination with that claim set, and probably fairly quickly get your German national patent to sit alongside your unitary patent. This slide shows which countries literal double protection is allowed in the examples that I gave. That is a unitary patent alongside a national patent. So you see in Austria, Denmark, Estonia, Finland, France, Germany, and Italy it is, and in some other countries it's not. The reason it's allowed now is that those countries where we see yes have modified their patent laws to allow this exact type of double patenting. So a second strategy, which can even be combined with the first strategy, would include a utility model. And we heard a few words about utility models already. And so in this case, you would end up with a unitary patent alongside a utility model, or a unitary patent, a German national patent, and a German utility model. So we could do it either way. Let's look at some of the pros and cons of a German or Finnish utility model. Utility models are national rights, and they're available in a large number, but not all of the European countries. So it's a quick registration, but it only provides 10 years of protection. It provides you with the same rights as a patent, but certain kinds of claims are not protectable. And I think there was a question in the Q&A about methods and utility patents. Method claims per se are not protectable, but specific use claims could be. And only specific certain types of technology are not subject to utility model protection. Another pro is low costs, but a con is that it's somewhat inflexible and you can't change your utility model during the registration process, but only in response to an invalidation attack. And so finally, I want to mention a third strategy, and this is where you would get a unitary patent, and then before grant, you file a divisional application, and that divisional application you validate as a classic European patent in the countries that you're interested in, and you opt the patent out of the jurisdiction of the Unified Patent Court. So you have a European unitary patent and you have a classic European patent sitting side by side that's not within the jurisdiction of the UPC. So this adds extra protection. And in this case, the claims have to be somewhat different.
So after Robert explained ways that we can layer maybe our protection, especially using national routes. What about thinking what you need to consider when you try to exploit your patented invention with a partner? Maybe you are co-owners, so you have a co-ownership agreement, or you want to license or take a license. So the EPO published fairly recently a study that is focused on SMEs and their patent commercialization activities in Europe. We see from this data that 2/3 of the inventions actually that were patented at the EPO are commercially exploited. And of the 33% that are not exploited is because they are still in the development phase. And out of this 2/3, basically half is exploited by the SME alone, and the other half with external partners. And how that is exploited. 62% of the respondents mentioned that they exploit their patented invention with a license agreement. Other use broader form of cooperation, spin-off, or cross-licensing. Of course, you see that these numbers don't per se add to 100%, so it means that multiple choices are used actually. And why these tools are picked, why they serve the needs of the SMEs. First, of course, it's increasing revenue. If you are not able to enter a market, it's easy to do when you have a license agreement and you have a local partner that can open that market for you. It has also a better market intelligence. Also, it facilitates joint innovation. We have also co-ownership for this in this respect. Outsourcing manufacturing, this is also an important factor. But also at the end, we see that there is a need of using license agreement, especially for settling infringement cases. And actually, Eskil hinted at that because we can see that what's happening at the UPC is exactly that. Because the UPC is fast, efficient, and fairly patent friendly, the threat of a permanent injunction in
about 14 months is bringing a lot of reluctant infringers at the negotiation table. And so very often, these cases end with a license agreement or a cross-license agreement. We see here, we have only representative settlements. We see press releases about that, so the details are not public, but the parties often declare, okay, we settled, we took a license. I like to refer in particular to the settlement between Interdigital and Oppo in October 2024 as an example of what the UPC is bringing to the table. It's what Martin said before about, we are trained to be risk averse, really struck a chord. I totally agree with him. But yes, I'm also amazed at what the UPC is doing. Let's take this example. Interdigital Oppo had a litigation history before that is not very long at international courts. And before the UPC started, actually Oppo was enjoined by several German courts. And what Oppo decided to do is to leave the German market, but to keep selling its products in the rest of Europe. And that was something that they could do. After Interdigital filed the UPC, an agreement was reached between the parties, and Oppo agreed to take a license. So with that, what is a license? These are very, very basic questions, but as Csaba mentioned, think about this before you have your conversation with your IP professional, IP attorney at law. What are you looking for in a license agreement? Are you looking to grant right to manufacture or to distribute? Are you granting, of course, what are you granting? A patent or also know-how? Often patent and know-how go together. And are there certain restrictions? Like, let's say that your invention applies to different technical fields, and maybe you want to reserve only to yourself one of this field and license another field. So these are thoughts that will really facilitate your discussion with your attorney. And also where? All the territories? Of course, if both for classic European patents, you can decide to limit the territory. Like, let's say you have a patent validated in UK, Germany, and France. You may license only in the UK. But the same you can do with the Unitary Patent. You can license only part of the territory, not all. You're not obliged to license the patent for all 18 countries. And how? Is it exclusive? I mentioned that sometimes so you pick one licensee or non-exclusive, more licensees. There may be a sub-license that is allowed. So here is a very, very basic, easy decision-making tree for licensing that in a way guides you through patent prosecution when the European patent sends you the communication of the intention to grant a patent. Actually, before that, you should already start to think which type of patent I want. Well, I want a unitary patent versus a classic European patent. And of course, it's the patent owner who has the right to decide. But we know that many times the licensee plays a role even at the patent prosecution phase, especially when we have non-European patent owners. Sometimes the European patent prosecution procedure in front of the European Patent Office is paid by the licensee. And we have in the license agreement the conditions under which the two parties cooperate. So it's important to think about, okay, is it really only the patent owner who will have the right to decide, or also the licensee will have a say in this respect? Think about in the license agreement what is your preferred position. In the event a classic European patent is chosen, will be opted out, or at a certain point maybe the opt-out can be withdrawn. Who is going to decide? Of course, by default is the patent owner, but we will speak in the next slide about the pinning effect. Sometimes a licensee can start an action, and that affects the right of the patent owner to withdraw or to do the opt-out. With respect to a unitary patent, like the license and the rights of licensee and the sub-licensing can be subject to a law of in a particular member state of the European Union that you cannot determine at the beginning, especially when you have patent owners that don't have residence principle or a place of business in Europe. So, sorry, is important that the more precise you are, the more you have control about all these options and topics. And also the litigation strategy is very important. Let's give an example. There are rules in the new system where if you have a non-opted out patent and an action is started by, for instance, a licensee at the UPC, then you cannot opt out the patent for the entire life of the patent. And the opposite is also true. Your patent was not opted out. A licensee starts a infringement action, for instance, before a national court, then the patent cannot be brought to the UPC system anymore. So you see that because of this mechanism, it's very important that you think about what is the licensee allowed to do under the license agreement? Is he able to start a litigation by himself, or the consent of the patent owner is needed? So, and we are saying that because actually, if you sign a exclusive license agreement, the exclusive licensee, has the right actually to start a litigation without the patent owner prior consent. The licensee needs only to inform the patent owner. And vice versa, the non-exclusive licensee is not allowed by default to start autonomously an action without the patent owner prior consent. The good news is that you can request the patent owner prior consent in your license agreement. That's important. If you put that in your license agreement, this is how the licensee needs to behave. So we have here some questions, some topic that you would like to think about before having your discussion with an attorney. And we summarized some of the consideration we just referred to. So who has the right to choose which type of patent will be requested? Who has the right to choose to opt out or withdraw the opt out in the future? Like there may be an infringement case that you want to actually withdraw the opt out and use the UPC, because for that case, that is the best solution for you. Is the licensee able to start autonomously an action? Normally, it's not in the patent owner's best interest. At least the patent owner should be able to express its consent or refuse it. The litigation. Also, let's see if the sub-licensing, is your licensee able to sub-license? Maybe you granted the right to manufacture to your licensee in another country. Is that licensee able to sub-license that right? The same decision-making tree can be applied in case of co-ownership. And in this case, it's actually more complicated because while by default is the patent owner who has these rights, the co-owners usually, it's not always the case, but usually have the same rights. So bringing together multiple parties is always a today, Dick. So if you have the possibility to discuss with a patent professional, attorney at law, patent attorney, what is the best actually the legal structure to the collaboration before the collaboration starts, it's better, because sometimes you can have an alternative. Instead of having a co-ownership agreement that really complicates a lot things, maybe you can have one party, one co-owner, let's say, that becomes the exclusive owner, and then there is a license agreement between the party. Well, the other party has a royalty-free license. So there are maybe ways to structure it differently. So also here, it's very, very important that you ask yourself these questions before the cooperation is formalized in a legal form. Here, I would not repeat what I said already with respect to license agreement, because the same considerations apply. But there is a point that is very important: the opt-out. The opt-out, the consent of all co-owners is necessary for an opt-out. And we have had already a case at the UPC where, unfortunately, for the new wireless, there was a co-owner. The opt-out was not deemed valid by the court because there was no evidence that the consent of the other co-owner was provided. There was nothing in the file that indicated, and of course, it was not, the opt-out was not done also in the name of the other co-owner. And so it's very, very important that if there is a co-ownership situation, the consent of all co-owners is obtained before filing an opt-out. So another example, and that's just for you to understand what may be the topic that you need to discuss with a professional. Let's say that in the event of a unitary patent, this unitary patent may be subject to German law or French law. There are some rules in the new system. So under certain UPC member states law, a co-owner may not transfer or grant a license for the entire life of a unitary patent without the consent of the other co-owners, but may, for instance, transfer its share of the patent, or may grant a license to use the patent in place of itself. So are you comfortable with this? Maybe you want to regulate this case in your ownership agreement, because that may be not the right solution for you. And here we have also some basic questions that will clarify for you what is your preferred position with respect to when drafting a ownership agreement. As I said, the earlier is the best, because maybe you can structure a collaboration not as a co-ownership, because it's always a little bit more complicated. So what is the choice of law? There are certain rules also when you file an application, actually, that can determine that. And opt-out, opt-in, the rights to use, exploit, and license, and how you manage disputes, as we saw, that may be complicated. So, and as Stephanie mentioned earlier, here is the link to the article we wrote that goes much more in detail. But for the sake of time, this is also, you can use the link to access the article.
Thank you very much, Mariella and Robert, for sharing these, well, bounty of insights, let's say. It's really lots of insights to share. Maybe as we slowly transition to the panel discussion, and I'm inviting the remaining speakers who are here with us on the stage again. So what do you think, you mentioned already, it's always getting complicated if you have different people sitting at one table. What are you, from your experience, what are, the greatest challenges that specifically smaller companies face in setting up the licensing agreements? And I mean, we're already doing things to raise awareness and prepare them a bit, but still, I could imagine that we have people in the audience thinking, but where do I start with all of that? So maybe the most fundamental questions that you feel are recurrent ones when people want to start setting up licensing agreements. Maybe you could comment on that a little bit more from your experience.
Yeah, so from my experience, but also from the data that we saw in the EPO study, actually SMEs use a lot license agreement, and that's very good. Often it's with another European partner, so it's very, very useful tool. And I think that the most important thing is that when you write a license agreement, you have to think about the strategy. Also, these down the road questions that sometimes the parties don't want to think about. That is to the solution. Usually the parties, the SME say, but it's difficult to negotiate these clauses. But actually, it's very important because it clarifies and simplifies the actually enforcement and the result. And to me, the big takeaway is really how the UPC is facilitating this license agreements and these settlements.
We've also received a question from someone from the audience, and he says, for startups with an existing strong patent portfolio, when exploring joint ventures, to him it sounds like one should be very careful regarding patent and licensing rights with the new partner. Is that something that that resonates, that you feel is valid? Probably hard to answer on a global scale, but
yes, startups often have an option that I see that is used a lot is like actually to have investors take an equity. So, but actually when you have a startup and a big corporation, sometimes license is an option, and especially when you can separate the fields of use. So I think it's we can really leverage this instrument to expand especially to internationalize the scope of activity. And with this respect, the Unitary Patent should be maybe something that small and medium enterprises should consider more, because imagine like how that expands the scope, the geographical scope of action of a license agreement. And when you can also license part of the Unitary Patent with different non-exclusive licensee, that can really allow a very flexible strategy of exploitation of the patented invention in Europe.
I'd like to add to what Mariella said. I think it's important, she mentioned it, but I think it's really an important point that there are default positions of the Unified Patent Court agreement, but almost all of these default positions, that is what would happen in the absence of an agreement, they're not mandatory. You can write your agreement to control the relationship between you and a co-owner or you and a licensee the way you want. So if there are any sort of template agreements that you get online or whatever that are sort of pre-UPC, look at the checklist that Mariella put together and make sure those issues are addressed the way you want them to be, because it's not the UPC. Some of the really, let's say, harsh default positions are not mandatory.
There's another question just come in and asking, to what extent is the UPC, and then in brackets, not posing a central revocation risk to startups, SMEs with limited resources, to defend themselves when being confronted with the threat of proceedings in front of the UPC based on a unitary patent filed by foreign entities? So complex questions, but maybe you have some thoughts on that.
So just to be clear, is the question about the centralized revocation proceeding on a startup's patent?
That's how I read it, yes.
Okay. So one of the things that could mitigate against the risk of that is to use, say, one of the strategies where you have a unitary patent and a German national patent. So at least you have multiple patent rights in Europe, especially in an important jurisdiction. It's interesting that what we've seen from statistics of the central division courts that manage standalone revocation actions is that the patents are upheld roughly at the same rate as, say, in the opposition division. They're about 1/3 are upheld the claims are upheld as is. About 1/3 are amended, probably almost certainly narrowed to some extent, and 1/3 are revoked. So it's actually pretty patent friendly even on the revocation side.
Thanks. I hope this was helpful to the person asking that. Okay, in the interest of time, maybe we open up the group of people. I see Martin still with us. Maybe also Eskil. Not sure. We've already covered most of the questions. The one still pending, and which is now going back to Martin once again, was the question concerning, first statistics on who's benefited the most so far. So maybe a rough idea or data that we have on that would probably be very much appreciated by the person asking the question.
Thanks, Stephanie. I did a bit of research on that question, actually, because I was nosing myself too. But the cheers go to the EPO and to Eskil, because there is an EPO unitary patent dashboard available that actually has all these data. So the uptake, so meaning the rate of European patents that are after grant validated as a unitary patent, is in European or from European applicants almost 40%. And internationally, it's only 28%. So if you would understand that as a well, who is benefiting from that system in terms of who is using that system more, then it's the European applicants that are benefiting, meaning using the system more. And in terms of small and medium enterprises and large enterprises, well, the most recent number that I found is SMEs is a share of about 32%, and large enterprises is about 60%, and the rest is universities and public research organizations. But that is not saying that SMEs are not benefiting enough or under proportionate. It's simply, in my mind, reflects the share of the overall patents that are just more filed by large enterprises than by small and medium enterprises. So I would not overinterpret that relation here. But I would really highly recommend this unitary patent dashboard of the EPO. It's a fantastic tool, and whoever programs that is a great one.
Thanks, Martin, for doing such a quick research also on the fly, and for sharing that with us. There's another question, and I think this one goes to Adéla from the EIC, whether there are any financial support schemes for corresponding fees for patent filings for innovations that are the result from EIC projects.
Yeah, that's a very good question. So for the EIC projects as such, I can mention that patent filing fees actually can be considered an eligible cost in your project. So if you have foreseen those costs already in your budget, then you are in the best position to actually be able to claim them. even if you have not explicitly foreseen them, they can be considered to be eligible under the conditions of the EIC if they are incurred in connection to the project necessary for its implementation and they are reasonable and justified. That's important. So not all patent filing fees or not all costs would be potentially accepted by your project officer. So I would always recommend you to check with the project officer in advance to see if the costs will be accepted. But in principle, if they comply with eligibility criteria, they should be acceptable. And then also, of course, Eskil mentioned some discounts that you can benefit from at the EPO. So always check if you fulfill the criteria to get those discounts. And what I could also mention is that there is the SME fund that is managed by the EU EPO, the European Union Intellectual Property Office, and they provide vouchers, like discount vouchers for filing of different IP rights. So there is a voucher for trademarks, one is for designs, one is for plant variety rights, and one is for patents. So you can also apply there for the patent voucher. But here I have to make a disclaimer, the patent voucher gets exhausted very quickly. So the SME fund opens every year. I think this year it was in January, so I assume it usually is January of each year. But the patent voucher usually does not, let's say, have the money available for a very long time. So I would recommend you, if you would like to apply for these discounts, keep an eye on it and be prepared at the moment when the SME fund opens for the given year, and then apply for the voucher as quick as possible so that you are one of the first ones.
Thank you, Adéla. Maybe just one quick follow-up question. Csaba had to leave to another meeting, but there was one, and I wanted just to bring it up to the attention because I think it's a very frequent question concerning freedom to operate. And how do you see that, for beneficiaries, or if you want to apply for an EIC project? Is that something that you like to see as well? How's your perspective on that? Csaba clearly said it's a must. Maybe would you agree?
Well, it's not a must officially when we talk about Pathfinder and transition.
Yeah.
So you don't have to submit freedom to operate search to us when you are applying to Pathfinder and transition. In Accelerator, if I'm not mistaken, it is already required. But I can say that, for example, in transition, we actually expect the projects to carry out the freedom to operate search during the project. So it is not that it would be mandatory. We don't write it down anywhere as a requirement, but we do expect it. And the vast majority of the projects actually carry out an FTO search during a transition project. And maybe many of them also during the Pathfinder already.
Wonderful. In the interest of time, maybe we swiftly come to the key takeaways that Adéla, you and Thomas wanted to share.
Okay.
So I give the floor to you.
Good, thanks a lot, Stephanie. So just quickly to wrap up, we have prepared a few final takeaways together with Thomas Bereuter from the EPO, because we have heard a lot of information today, and I imagine that it must have been a little bit overwhelming for some that are new to the topic. So we have prepared just a few slides to highlight the main points and main, let's say, recommendations to the audience, and in particular to the EIC beneficiaries. So what would be the main advantages of the unitary patent in our view? So what you should consider is that the unitary patent is cost effective, of course. It provides a broader protection at a lower cost if you are aiming at a broad international coverage, let's say, which I believe is the case in many of the EIC projects, or majority of the EIC projects. So with the unitary patent, you can get that broad coverage for a much, much smaller cost. For that reason, this is particularly interesting for the EIC beneficiaries, because EIC beneficiaries, as I already mentioned earlier today, they usually are on a tight budget, and they have strong technologies, and they are aiming at very broad commercialization. So in particular for you as EIC beneficiaries, this definitely is something that you should consider. And of course, the unitary patent also offers simplification. So the management of the system is, let's say, or management of your unitary patents will be simpler than in case of national validations. So what steps you can take then in your everyday business? I think that in the case study of Csaba, that was very well demonstrated that you should be always aiming at informed decisions. So compare the options that you have, the unitary patent, the classical European patent validations, and national patent, and decide what would be the best strategy for you in each individual case. In Csaba's presentation, there was also this interesting aspect. He was mentioning that you should be, or that they are also discussing with their patent attorney the total costs. So don't hesitate to ask your patent attorney also for estimates. Let's say, how much would that cost me with that option, and how much would that cost me with the other option, so that you have all information necessary that you can make those informed decisions. Reconsider your strategy in every case, I would say. So there might be some companies that they decide they will always go for the unitary patent, but I would say don't get stuck on your opinion, and don't hesitate to revise it in certain cases. I would say it's better to consider it really in each individual case. And for contracts and for collaborations, use those checklists that were presented today, or make your own checklists and use them when you discuss with IP experts, consultants, or patent attorneys, because that will also simplify for you the whole process and maybe also save you significant amount of cost if you are well prepared. In terms of risk management, so what you should consider to minimize your risks when applying for patents and deciding on the different options that you have. So don't forget that freedom to operate is very important, and it remains important also with the unitary patent, and in some cases it even becomes, let's say, more relevant than before, because with the unitary patent you are maybe entering different markets than what you expected you would be entering. But it doesn't mean, the fact that you get a unitary patent in these markets, it doesn't mean that you actually have freedom to operate in them. So you might need to have broader FTO scope, let's say, and you definitely should not forget about conducting freedom to operate searches and doing them also regularly, of course. Regarding the opt-out provisions, so you know after today that there is the possibility for the European patent, the classical European patent, to be opted out from the jurisdiction of the Unified Patent Court. So don't forget about this option. So check if this is something interesting for you, and in case that you consider it interesting, let's say it might broaden your options, and it might give you maybe a little bit of security if you use this option for certain patents to, let's say, avoid having all eggs in one basket. And yeah, examine options where necessary. So whenever you are making a decision, redo the process of thinking, like of what options you have, what are the possibilities, what are the risks, what are the advantages. So examine your options every time you make a decision, and manage the risk so that you don't have all eggs in the basket. And now I will hand over to Thomas, because Thomas is actually our expert on IP strategy. So he would also like to give you a few last considerations regarding your IP strategy. So Thomas, up to you.
Thank you, Adéla. Yeah, coming back to the question that was raised before, who is benefiting more? Just a quick comment to the statistics that Martin brought up. The 32% of SMEs, that is a higher rate than SMEs making use of the European patent system. That means more SMEs are actively using it. But it still doesn't answer the question, who is benefiting more? It's only they are using it more, but if they benefit, that's a different thing. And I would say, I would answer to that question, the one who knows best how to make use of the unitary patent system will benefit more. You know, that is the reason why we have this event, why we have created the title for the event. You know, there's a saying, if one has only a hammer, every problem looks like a nail. And everyone who fixed something at home knows that a hammer alone is not enough. So you want to understand it. That is why today we looked at the unitary patent system from different angles. So a lot of time we spent on the IP management perspective, but also from a strategic point of view. What does make sense? Yeah, and with the introduction of the unitary patent system, we had an interesting reaction from businesses, not only once, that I would like to share with you. They told us we feel at a crossroads. The system made us rethink and advance our IP strategy. And why is that? Now we're coming to the slides. On the one hand, you need to make informed decisions for each patent family as you have more options, but its pros and cons. We talked about that. In addition, the unitary patent brings new opportunities. It simplifies access to multiple markets. This helps businesses bring products and services to new regions. It opens licensing opportunities in markets the company does not serve itself. So you're not selling your own products, offering your own services. Let others do it and cash in. Enforcement. It becomes more effective across borders, so you have less complexity. And that makes it much more realistic that also the enforcement can become part of the revenue stream of the business. And something that is also understood by investors that also support financially the enforcement. Then for many deep tech companies, in particular EIC beneficiaries, that product market fit is often not yet clear. In particular, in those many cases where EIC is supporting platform technologies. What those companies need is the right to pivot, or in other words, optionality. The unitary patent supports this flexibility. You don't need to know in advance all aspects of the market. The flexibility to adapt to a better market understanding that you gain while doing your business, the respondents to changing markets, to address new opportunities, that's facilitated by the unitary patent system. And there's another aspect. The cost savings from the system can be reinvested. You can reinvest them in expanding and diversify the IP portfolio. Here, a short comment to trade secrets. Don't believe that trade secrets come for free only because you don't pay fees. You will pay your attorneys quite something to enforce your trade secrets. You not only enforce, to keep your secrets secured. You need to have solid contracts and so on, and that will cost you money. It will cost you an effort. So the trade secret question should not be a question about cost. It should be about how to make best use and how to make the best combination of the different form of IP protection you can get. And finally, a well-structured and optimized IP portfolio makes a business more attractive to investors because it shows foresight and commitment to sustained value creation. That is why we strongly advocate for an articulated IP strategy that makes communication around IP management much easier, and many of the questions we discussed today can be then addressed, and the outcome will be much more effective. With more options on the table, like now with the unitary patent, and it has created many options, as you heard, it becomes even more relevant to understand and communicate how patents create value for your business. Everyone can innovate, but no one can innovate alone. And that brings us to communication. So internally, this means you have to bring together the IP professionals, the R&D teams, the legal experts for aligning their objectives. As Martin said, where's the goal? You need to address the goal. And externally, it means collaborating with other businesses and or universities and engaging patent attorneys, IP advisors, and investors. Only then, and an IP strategy can be truly understood, aligned, and executed. So my encouragement for you, think about how the unitary patent can advance your own approach to IP. And if you would like to continue the exchange, reflecting, sharing, and building on these topics, please follow us on the High Growth Technology Business Initiative on LinkedIn. This is something we created together with our partners, in particular with LESI, the Licensing Executive Society International. And it is meant to support technology-driven businesses, to support people like you. So thank you. And with that, we are coming to an end. So back to Stephanie.
Thanks, Adéla and Thomas, for wrapping up this session so nicely. So not much for me to add. Thank you to everyone who stayed with us for this long, 10 minutes longer than expected. But we hope, as said in the beginning, it was insightful and inspiring. Thank you very much to all of our speakers for sharing your views, perspectives, and raising, hopefully, interest in the unitary patent system, the patent protection, and in general, thinking of IP in a more strategic manner from the very beginning. So thank you, everyone. And as said, we've shared the link to the course room where you'll find the recording, the presentation, additional resources. So please make sure to pop by and have a look. And then hopefully we'll see each other soon in another training session. Thanks, everyone, and have a great evening.